Does Korean law recognize a right to bring a civil action for damages against your spouse's special friend who expressed her or his love for your spouse on social media? The answer is yes, unless it is a unilateral action. Here is an example. There are some people out there going through their spouse's smartphone for any clue as to whether their spouse is cheating on them. In doing this, they sometimes discover in their spouse's social media posts something that hints he or she is cheating. The social media post can also be brought to your attention by your friend. In January 2016, a Korean woman shared on her Instagram a photo of herself dating a married man. The social media post was brought to his wife's attention by a friend of his wife's. His wife decided to take the matter to court. The lawsuit against her husband's special friend was seeking monetary damages for emotional distress caused to her by it. Though she failed to demonstrate that her husband had ever had sex with the defendant, she said that he clearly did something he should not have done. In South Korea, having an affair, regardless of having sex or not, constitutes a tort. The essential element of the tort is that your marriage has to be interfered with and that interference has to be highly offensive to a reasonable person. In this case, a damages award of 15 million South Korean won was handed down for a photo shared on Instagram. Does this seem like a lot? The tort of interference with a marriage has been fully recognized in Korean law. A Korean court's damages award to the victim of the tort of interference with a marriage ranges from 10 million South Korean won to 30 million South Korean won during the analysis year, 2010 to 2019. Why don't we take a look at what other countries are doing for those who want to sue their spouse's lover? Let's take an example of the US. Where an outsider interferes with a marriage, a spouse possibly makes alienation of affection lawsuit against the outsider. However, not all of the U.S. states do acknowledge the legal claim of alienation of affection. Only 6 states in the U.S. has legally recognized alienation of affection: Hawaii, North Carolina, Mississippi, New Mexico, South Dakota, and Utah as of 2016. The spouse as a plaintiff generally claims the outsider should be responsible for damaging a marriage by committing certain actions, for example adulterous cheating with the other spouse. Are sexual relationships between one spouse and a lover the prerequisite to the proof of claim in these states of the U.S.? Generally no. Sexual relationships between one spouse and a lover are not required to prove the other spouse has suffered the loss of affection in general, as in South Korea. For example, let us look at the legal requirements in North Carolina. The state court in North Carolina recognizes 3 requirements for the claim. A plaintiff should prove: 1. The plaintiff and the other spouse are happily married and genuine affection exists. 2. Love and affection was alienated and destroyed. 3. The malicious acts of the defendant produced the alienation of affection. The malice does not always mean sexual relationships with regards to the 3rd requirement according to the court. The above suggests that there is a similarity between South Korea and the 6 states of the U.S. Advice.